The reason why we have patent laws and copyright laws is to reward human work and endeavor and human ingenuity. It takes a long time, a lot of blood, sweat, and toil to write a book, come up with a new invention, to learn a whole field, and then innovate upon that field, right? And that's why we reward people with a 20-year monopoly in the case of a patent. But if all that can be achieved with a prompt into AI, are we rewarding the right thing?
Larissa, Gina, welcome to the AI ChatRoom. I'm really excited for this conversation today. You know, IP lawyers are very popular all of a sudden, and I know you two have been on the forefront of these issues. So why don't we start with just introductions? Larissa, tell us a little bit about yourself.
Sure. So my name's Larissa Bifano. I'm a partner in DLA Piper's patent group. I advise all types of companies how to protect their technology and help them strategize about how to protect their companies and innovations.
And you have an interesting background in physics, I believe?
I do, yeah. So I majored in physics because my father was a lawyer, and then my grandfather actually built a shell for one of the atomic bombs and worked on the Manhattan Project. And he steered me into science. And then I got steered back into law, and now I'm a patent lawyer.
Since I came to DLA, you were one of the first people I was visiting with about AI back 5 years ago when we founded the group, and you were already patenting AI, had been patenting AI quite a long time back then, but a lot has changed.
There's a lot of people that think, oh, AI is just this thing that has come up in the past 6 months or so, but I think what has happened now is that it's more democratized now. So anyone can experience AI, anyone can go to various websites, type in a prompt, and see how AI works. But 10, 15, 30, 50 years ago, it was really in the realm of scientists and engineers and researchers that were using AI to model complex systems. So this has been around for a long time, and we've been patenting these types of things for a long time.
Gina, you practice a different type of IP law that has also become very much in the news these days. So tell us about yourself.
Sure. Well, I'm a copyright, trademark, right of publicity, unfair practices lawyer. I don't do patent law like Larissa, but I have to say, with copyright being such a big issue with generative AI, I spend almost every day advising on AI and the intersection of copyright issues and sometimes those other principles of IP law as well.
Yeah, so give us some examples of the real world questions you're facing.
A lot of use cases we see are around advertising, for example. A lot of AI-generated ads now, because if you think about it, you can save on, not having to hire live humans, for example, as models. And now that can be sort of controversial depending on what industry you're in, but it's something that a lot of clients are thinking about. To generate imagery through a text-to-image generator, it's much easier to do that now than it used to be, obviously. And you can generate text, you can generate keyword ideas, et cetera, using the large language models. So there's a lot of different ways these models come together to make it more efficient to produce a big promotional piece for the company.
Larissa, how about you? Let's talk about the question of AI outputs and inventorship.
I think it depends a lot on how those outputs have been generated. So the Patent Office has come out and said that only human beings can be inventors of patents. So only a human being can apply for a patent and have a patent granted. So what that means is you can't list AI as an inventor. So if there is some invention that AI should be listed as an inventor because AI conceived or reduced to practice the invention, then that invention cannot be patented. And that can be a big deal. Like if there are companies either in the semiconductor, the computer science spaces, or in the pharmaceutical industry, for example, that can't get patents for their innovations, that is going to be a problem, I think, for the industry. But I think we're not there yet. Right, so I think that we're not yet at the point where AI is acting on its own and generating these inventions without the aid or without a human in the loop to achieve the invention. So AI is not necessarily conceiving these inventions, sort of the light bulb is not going off in the computer that says this is the invention. And there's also significant human involvement along the way in the development of the invention. When we are writing patent applications and developing a patent strategy, we ask the engineers, what are you using? Like, what tools are you using? Are you using generative AI? How are you using generative AI? And what are you adding to the process? Because it's really what the human is contributing to the process that will be patentable.
Gina, when we look at AI-generated imagery, one of the issues that's very in the news lately is, creation and who is the author of AI-generated work. What are you seeing with clients?
It's a big issue as well with copyright, right? Because there's a question as to who owns the outputs from generative AI. Just as Larissa just mentioned on the patent side, the United States Copyright Office says that the author of a copyrighted work must be a human. So you can't have a purely generated AI work and get copyright protection for it. But it's not likely that when you have a generative AI tool integrated into a corporate environment, that the generative AI is doing all of the work. You do have human intervention. You do often use the generative AI for ideation, and then the human takes it from there. Or you put pieces of the AI outputs together. And if you're doing that, you're going to have some human authorship and some copyrightability in the final work product.
Gina, you're helping people understand what's the right way to use these tools to protect trademarks and copyrights, to avoid running afoul. So talk to us about that. What do you want clients to know?
You really have to understand the model is being used, one, and you need to really understand the facts of the use case. That's really the only way we can properly advise a client, and that's why we really like to work closely one-on-one with our clients so we do understand those issues. But to your point about making sure that the company owns work that it's created, so if there's copyright protection out there, there are protocols that we can put in place to make sure that authorship is tracked and the protection is ultimately obtained. If you're working with a vendor who may be creating work for you, right, we have great recommendations on how to frame up those contracts so that you, as the recipient of that vendor's work, does own that work product to the extent you need to own it.
So what we've been advising our clients on the patent side is to keep track of or identify where there have been humans involved in the process, because that's what's going to ensure that we can get the right amount of patent protection for the innovation. And one thing that's come up as a way to do that is, so before there was a big law change in 2012, there was the the US awarded patents on a first to invent. So if I invented something first and then Gina filed first, I could show that I was the prior inventor and I would get the invention, get the patent awarded. But we changed the law to follow the rest of the world, and it's a first to file. So there used to be lab notebooks that every engineer would keep so that you could prove the date of conception and the prior invention date. Since the law changed, it's less important to have those lab notebooks. But now there's a situation where you want to record the human's involvement in the process. And you want to document what inputs maybe were provided to the generative AI, what came out, how the human iterated on that, and then how the invention came out of that. So it could be that we see a resurgence in engineers keeping lab notebooks so that later, when we're in a litigation, we can prove, if we're the patent owner, we can prove that this is a patentable subject matter, that the humans are the right inventors, and this should be worthy of a patent.
So let's transition now to the complicated world of AI rules and regulations that are coming. Gina, what do you see coming out of the Copyright and Trademark Office?
I don't see any big changes necessarily coming out of those two government offices. I mean, both offices are studying the impact of generative AI. They're trying to get smarter about their practices, but I don't see any big changes on the legislative front anytime soon. I think we're going to take a lot of direction from case law cases that are currently pending in our courts. And frankly, there's a lot of cases already on the books that give us insight into how to analyze incoming IP risks that can come up in the generative AI context if you're not using it the right way.
What do you see on the patent side?
Similarly, on the patent side, I don't see changes really in the patent office coming about, at least on respect to inventorship. But I think what will be interesting to see play out in litigation is challenges to the enforceability of a patent. So this inventorship issue plays out when the patent is granted, and if there is a patent that's granted and it does not name the correct inventors, it can be rendered unenforceable because you're required to name the correct inventors on the patent. And this happens all the time if you have a joint collaboration, say, and I collaborate with you, but I don't want to list you on the patent because I want to own it, and I exclude you, and then you sue and say that you should have been named, and then the patent's unenforceable.
One thing I love is that we're all three litigators who spend a lot of time trying to help our clients prevent litigation, so with risks and controls and things like that. But are there business solutions to really get ahead of these issues? Like let's take the copyright example.
Yeah, I mean, I think there'll be a big push to have some business solutions because there's so much uncertainty in the law, and there will be for a long time. So, I mean, a big topic of conversation right now is whether there should be compensation for authors or artists, right, who may have works that go into the training models. That's a very complicated issue, right? There's a system of licenses that may already have something to say about whether there can be ingestion of that work. But in other instances, I think there's an open question as to whether there should be, a system of compensation for using a work in a training situation, because it's not the same as using an all-out copy of a work, right? It is a very different use, and that makes it a very difficult issue that we don't have a cookie-cutter economic model for, at least not yet.
And on the patent side, I think that the business needs to know what AI they're using and know how their engineers are using AI so that they can proactively insert humans or make sure that there are humans inserted in the loop so that we can ensure that we can get adequate patent protection. So it's sort of understanding how your engineers and employees are using the AI tools and their day-to-day innovations so that we can make sure that what they're innovating can be protectable.
What about technical solutions to these issues?
That's something that we often explore with our clients because, the law or mitigations to deal with the risk can only take you so far because of the ongoing uncertainty in the law. So we do often work with our data scientists or the engineers on the company side in order to figure out what technological solutions can be put in place to mitigate risk as well. There are filtering type situations that can be built into these models that can help mitigate infringement risks is just one example, Danny.
We've seen a lot of innovation in prompt engineering. So, you may use an existing large language model, but it's sort of how you use it that can be innovative, and how you are configuring the prompts, how you give feedback on the prompts, how you're trying to maybe use the model in a way that's going to alleviate some of these infringement issues, alleviate some of the issues with losing control over trade secrets. Say if you're putting in confidential information into an open model. And then we also are seeing companies that maybe don't want to use a large language model and we would want to build a smaller model so that it's not ingesting all of this data and ingesting all of these problems with it, but building smaller models that are more controllable and then are more fine-tuned to solving a specific problem. And we've seen that in the engineering space.
So you may not be able to patent the foundation model that someone else made, but you can patent what you've built on top of that.
Exactly.
And this goes back to, I think the way you and I thought about it years ago, maybe it's not the algorithm, but it's the way things are wired together. And we're really seeing that across the government and different agencies. A few years ago, the government was celebrating the first autonomous medical device, and now we're hearing, we don't do autonomous. We want humans in the loop. And I feel like there is this move of sort of pulling back that, it's hard for clients, and we have to help them. They've got a plan for the future, and then the ground keeps changing under them.
Yeah, well, I think there is this high-level theoretical question that everyone is grappling with is AI, particularly generative AI, a good thing or a bad thing, right? And I think we're seeing our government regulators grapple with that a lot as well. And I think that's why you're seeing the pendulum swing. But at the end of the day, from my perspective, I think, generative AI can be used for wonderful things. There's amazing applications. That doesn't mean that there aren't challenges. There are serious challenges associated with generative AI as well. I think we just need to be better at learning how to use the tool. And yes, I'm sure there needs to be some regulation of the tools. But I don't think you can, it's not an easy answer to is it good or is it bad? That's the wrong question.
You look at all these revolutions that have happened in technology over the course of humanity, like fire, right? So fire is really great. Like we all need fire, but it's really dangerous. It can kill people, right? And then you have industrial revolution, you have the age of computers, and every time there's been these huge innovations, there's downsides associated with them because we have to change how human beings function and operate and how our society operates. But there's huge pluses. I think in this situation, it's not doomsday, end of the world, AI is going to take over. AI is just going to change how we live our lives, how we work. It's going to enhance the way we live our lives.
Right. Or using a camera to create an image, right? That did not kill art as we know it. It just didn't. And I'm seeing some of that already with the text-to-image generative AI. You are seeing a new form of art that's coming out of those platforms. And again, it's not to say there aren't challenges, but there's also new art being created.
I think eventually we will hit a pushback where people say, okay, I just want to carve out a space for human creation. I think we crave that authenticity.
And bringing it back around to the disclosure issue, I do think it's important that people know what is generated by AI and what is not, if it's in a certain context where the consumer has a right to know.
Isn't it kind of similar to what we do with our food, right? So like we have to say when things are genetically modified, we have to let people know what they're eating, whether it's organic or what chemicals or pesticides are used with it.
What happens next for intellectual property law? Take us to the future.
I think that we're going to see more subject matter eligibility issues in the AI space and other types of advanced computing as they become more common. As AI is something that's in everybody's life, just like a computer now is in everyone's life, I think we're going to see more of those challenges. I think it remains to be seen how much of this is going to be on inventorship and how big a problem that's going to be for companies going forward. But I think it's subject matter eligibility is going to be the problem we see going forward. The reason why we have patent laws and copyright laws is to reward human work and endeavor and human ingenuity, right? So it takes a long time, a lot of blood, sweat, and toil to write a book, to come up with a new invention, to learn a whole field and then innovate upon that field, right? And that's why we reward people with a 20-year monopoly in the case of a patent. But if all that can be achieved with a prompt into AI, and all of a sudden you get the same amount of 20-year monopoly that you did after having a whole education and then working in a company and developing something, are we rewarding the right thing?
Well, this has been great. It's a testament to the exciting times that our wonky legal world these days is also pulling us into philosophical conversations about the meaning of creation and originality. But it's great to take a step back and think about the big picture in the ways you're helping clients with patents and with trademarks and copyrights. And we're grateful to have your insights here today.
Thanks for having us, Danny.
Thank you so much.